Greetings, my name is Jayaprabha Veerapan and my student ID is 0337587. This is my individual video presentation for Equity and Trust 1 module in the March 2022 semester. I will first start off with a brief introduction on the history of common law and equity, as well as the Judicature Act 1873. In my presentation, I will examine three main views on the effect of the Judicature Act, namely the orthodox, radical, and intermediate views. I will examine the justifications forwarded by scholars and judges for each of these schools of thoughts, and at the end of the video, I will conclude on whether Lord Depoc's famous statement advocating for the radical view represents the correct view of the effect of the Judicature Act 1873 in English law as well as Malaysian law. Historically, the law of England consisted of two distinct parts called common law and equity. The common law in England emerged after the Norman conquest when the king's judges applied common law to the whole of England, which is why it is called the common law. With time, the English common law became well known for its strictness and inflexibility. Subsequently, equity grew out of a subject's right to petition to the king directly for justice in certain situations resulting from common law strictness. Over time, such petitions began to be referred directly to the Lord Chancellor as the keeper of the king's conscience, and the Chancellor's office eventually became the Court of Chancery. The separation of law and equity resulted in practical inconvenience, as illustrated by Charles Dickens in his book where he wrote that equity sends questions to law, law sends the questions back to equity. Law finds it can't do this, equity finds it can't do that. Neither can be so much as say it can do anything, without this solicitor instructing and that counsel appearing. Additionally, the reputation of the Chancery courts was damaged by convictions of embezzlements and acceptance of bribes by the chancellors. All this added to the pressure to reform the court structure in England. The systems of common law and equity remained separate until 1873, when the Judicature Act 1873 was introduced. The Judicature Act 1873 essentially integrated the different courts administering common law and equity into a single Supreme Court of Judicature, ending an inconvenient institutional separation of common law and equity. The effect of the Judicature Act has been debated and disputed for the past 149 years after the passing of the Act. There are three main views on its effect, with the first one being that equity and common law would continue to have a separate existence. This view is referred to as the orthodox view. The second view is that the Judicature Act merged common law and equity into one subject matter and destroyed conceptual distinctions between them. This view is referred to as the radical view. The third view, called the intermediate view, suggests that common law and equity continues to develop in close proximity to one another, and that the court should attempt to harmonize the two whenever possible. I will now discuss each of these views in detail. A well-known statement advancing the orthodox view appeared in Ashburner's Principles of Equity, where the author, Professor Ashburner, stated that the two streams of jurisdiction, though they run in the same channel, run side by side and do not mingle their waters. The orthodox view was also expressed by Sir John Coleridge, who served as the Attorney General for England and Wales when the Supreme Court of Judicature Bill was debated in the Parliament. According to Sir John Coleridge, to talk of the fusion of law and equity is to talk ignorantly. Law and equity are two things inherently distinct, and the distinction is not capable of being destroyed by an Act of Parliament. Other proponents of the orthodox view include Meagher, Gamow, and Lehane, who in their book expressed that fusing common law and equity would result in a new body of principles comprising of rules conceived by accident, born by misadventure, and nourished by sour but high-minded wet nurses. One of the rationales behind the orthodox view is that the Judicature Act only fused the jurisdiction, procedure, and pleading of the Court of Law and Equity while preserving the substantive rules of common law and equity. This can be seen in the case of Salt against Cooper, where the court explained that the effect of the Judicature Act has been sometimes inaccurately called the fusion of law and equity, when in reality, there was no fusion or anything of the kind. Another case judgment which subscribes to the orthodox view is Roane against Stephens, where rules in common law and equity were clearly distinguished when the court held that a positive covenant is not enforceable in equity because it would contradict the common law rule of privity of contract. A Malaysian case which supports the orthodox view is Davey against Francis, where the High Court held that the answer to the objection that English equity is not applicable to land matters in Malaysia is that the land law of England is one thing and equity is another matter. Another justification of the orthodox view forwarded by Miguel Gamau and Lehane is that fusion is unnecessary because the nature of equitable and legal actions as well as remedies makes available plenty of causes of actions and remedies to provide a plaintiff with sufficient redress for their grievances. The orthodox view is also substantiated by the argument that the functions of common law and equity are practically distinct. Common law establishes rules to govern the generality of cases, while equity functions to restrict certain legal rights on grounds of unconscionability. An area of law which demonstrates inherent distinction between common law and equity is the assessment of damages in equity. For example, the assessment of equitable compensation may necessitate the disregard of common law limitations such as remoteness because a breach of equitable duty is subject to a more stringent standard of conduct as compared to an action for breach of contract. Other than that, proponents of the orthodox view also argue that fusing common law and equity would result in confusion in the application of law, which would be costly to litigants. This is because, without being tied to the roots of common law and equity, the new law would be free to develop in any way the courts deem fit without any guidance. Moving on to the second view, one of the most prominent advocates of the radical view is Lord Diplock. Lord Diplock, in his dictum in the case of United Scientific Holdings Limited against Burnley Borough Council, referred to Professor Ashburn's famous statement and expressed that the statement has become both mischievous and deceptive, and that the confluent streams of law and equity have surely mingled now. According to Lord Diplock, the conservatism of English lawyers is what may have made them slow to recognize that the Judicature Act 1873 fused common law and equity. Lord Diplock uses the examples of two rivers in France, Rhone and Saône, which meet in the center of Lyon to illustrate that although it is possible to discern equity from common law for a short period of time after the Judicature Act came into force, there comes a point where this is no longer possible. Another case judgment which subscribes to the radical view is the case of Bristol and West Building Society against Morthew, where Lord Justice Millett stated that the availability of equitable compensation rather than damages for breach of duty is just an effect of history, and it is a distinction without difference. A Malaysian case which supports the radical view is Kor Kwek Jin against Haji Yassin and others, where the federal court put together the cause of action for money had and received, which is a common law personal action, and constructive trust, which is a product of equity. By putting the two together, the federal court essentially amalgamated the forms of action at common law and in equity. Also advocating for the fusion of common law and equity is Professor Andrew Burrows, who supports fusion in refusal of being slaves to history, as well as in recognition of the importance of coherence in the law and of like cases being treated alike. Professor Burrows is of the opinion that fusing common law and equity would make the law in certain areas more comprehensible. For example, The law on mistake in contract, where under common law, mistake as to the quality of the subject matter of the contract generally does not vitiate the contract, which would remain valid and enforceable. However, with regard to the same type of mistake, Lord Justice Denning in Soule against Butcher held that equity can render the contract not void but voidable if the parties were under a common misapprehension, either as to facts or as to their rights, provided that the misunderstanding was fundamental and that the party seeking to set it aside was not himself at fault. Over the years, this decision has been subject to much criticism, but in 2020, the Supreme Court in test claimants in the Frank Investment Income Group litigation against Revenue and Customs suggested that equitable rescission for mistake might still be alive. Professor Burrows opines that nothing can be gained by differentiating common law and equity with regard to this matter, and that it would be better to say that serious common mistakes would render a contract void, while mistakes that are less serious would render a contract voidable. Now, moving on to the intermediate view, this school of thought suggests that common law and equity are being developed closely together, but they have not fused yet. This view can be derived from the case of Napier and Ettrick against Hunter, where Lord Gough stated that the two strands of authority are molded into a coherent whole. It is important to note that under the intermediate view, it is believed that there is still separation between common law and equity, although the court should try to harmonize them by reconciling technical difficulties between the two. The intermediate view is endorsed by Hanbury and Martin, who in their book stated that both legal and equitable rules have developed since 1873, and the development of legal rules has sometimes been influenced by established equitable doctrine, with the effect that a situation which would at one time have been treated differently and at law and in equity is now treated in the same manner. If that is what is meant by fusion, there is evidence of it. One case that illustrates the intermediate view is Attorney General against Blake, where account of profits and equitable remedy was awarded for a breach of contract. Lord Nichols, delivering the leading judgment in this case, said that when exceptionally a just response to a breach of contract so requires, the court should be able to grant the discretionary remedy of requiring a defendant to account to the plaintiff for the benefits he has received from his breach of contract. Furthermore, in the case of Tinsley against Milligan, Lord Brown Wilkinson stated that English law has one single law of property made up of legal and equitable interests, which, according to Jill Martin, facilitates the harmonious development of the common law and equitable rules on illegality. The decision in Tinsley was followed by the Malaysian Court of Appeal in Mustafa bin Osman against Lee Chuan and another, where it was held that property in chattels and land can pass under an illegal and unenforceable contract. It is important to note that although the reliance principle in Tinsley was overruled by the UK Supreme Court in Patel against Mirza, as well as the Malaysian Federal Court in Liputan Symphony Sendirian Berhad against Pembangunan Orchid Desa Sendirian Berhad, the intermediate view on fusion expressed in Tinsley is not affected. Another region of law which substantiates the intermediate view is the area of estoppels. The English courts appear to be flexible by unifying the various categories of estoppel, but this does not suggest that common law or equitable origins must be ignored. In the case of Amalgamated Investments and Property Company Limited in liquidation against Texas Commerce International Bank Limited, Lord Denning stated that the doctrine of estoppel has evolved during the last 150 years in a series of separate developments, and at the same time, it has been sought to be limited by a number of maxims such as estoppel cannot give rise to a cause of action, estoppel is only a rule of evidence, and so on. Lord Denning's view has been largely accepted by both English and Malaysian courts. Therefore, this area of law supports the intermediate view that common law and equity can mingle and be developed together. It is observed that the English and Malaysian courts in general favor the intermediate view on the effect of the Judicature Act. In conclusion, it is submitted that Lord Diplock's statement in United Scientific Holdings Limited against Burnley Borough Council is incorrect, as the English and Malaysian courts seem to favor the intermediate view that the rules in common law and equity are currently separate, but they should be developed together. However, there might come a time when Lord Diplock's statement may come true if common law and equity continues to be developed together, which may result in the eventual merge of the two. The more important question here is whether the current approach favored by the courts is more beneficial as compared to the orthodox and radical views. It is submitted that the answer to this is a definite yes for three main reasons. The first reason is that the orthodox view cannot be sustained in view of recent judicial developments by which more and more common law and equitable principles are being mingled together. Insisting on keeping common law and equity separate would result in uncertainty stemming from unnecessary distinctions, as can be seen in the area of law on mistake. The second reason is that the radical view cannot be sustained as well because a general fusion of common law and equity would be inappropriate in light of the nature of equitable principles, which are inherently distinct from common law as discussed previously. The third reason is that fusing common law and equity may lead to the death of equity, which is what happened in the United States as observed by Roscoe Pound. In a fused system, four trends can be observed, with the first one being that legal rules superseded equitable rules in certain cases. Secondly, equitable rules or parts of them disappeared. Thirdly, equitable principle became hard and fast in their application. Fourthly, equitable rules became confusing instead of supplementing legal rules. It is important to note that the decline of equity in Pound's observations was also influenced by a historical context and factors other than just an amalgamated system. Although it is inaccurate to say that a fused system was the only contributing factor to the decline of equity, it is nevertheless a valid concern. Therefore, the logical view as to the effect of the Judicature Act would be the intermediate view, which enables the principles in common law and equity to be developed harmoniously together without extreme and excessive measures to separate or fuse the two. Thank you.